On May 21, 2026, USCIS issued Policy Memorandum PM 602-0199. A policy memorandum is an internal guidance document issued by USCIS to instruct its officers how to apply existing immigration laws. It is not a new law passed by Congress. This memo has immediate effect and applies to both newly filed and many pending adjustment of status applications. We are breaking down everything you need to know. Check the timestamps on your screen to jump straight to the segment that impacts you more. This policy has serious flaws. It creates unnecessary uncertainty for professionals who have maintained lawful status for years. It ignores the practical realities of long visa backlogs, especially for Indian nationals. It risks disrupting critical U.S. industries that rely on skilled talent and may cause family separations without clear congressional authorization. Many legal experts believe the memo exceeds agency discretion and conflicts with INA Section 245, the section of the Immigration and Nationality Act that allows eligible individuals already in the United States to apply for a green card without leaving the country. Key concerns for our clients include unpredictable family disruption for dual IT professional households with children, business continuity risks at major tech employers in California, Texas, and Washington, and administrative burdens that outweigh any claimed efficiency gains. This policy is very likely to face strong legal challenges. Courts could pause or strike it down for being arbitrary, lacking proper notice and comment rulemaking, or failing to consider reliance interests of applicants already in the system. At the same time, it might be upheld in part. While we await possible court action, we must prepare strong cases immediately. Today, I'm going to explain exactly what this means for you and how we plan to respond. Understanding the policy change. For many years, adjustment of status, or AOS, inside the United States was the preferred and reliable route for employment-based immigrants who entered legally. AOS is the process of applying for a green card while already in the country. Congress created INA Section 245 for people who were inspected and admitted, meaning a border officer officially checked their documents and allowed them to enter, and who have approved immigrant petitions. The employer filed approval showing they qualify for a green card. The new memo reverses this long-standing practice. USCIS now treats consular processing abroad as the default. Consular processing means applying for an immigrant visa at a U.S. embassy or consulate outside the United States. Adjustment of status is now considered an extraordinary exception that requires a strong showing of positive discretionary factors. Important elements include officers weighing compliance, family ties, economic contributions, and length of residence under a totality of circumstances test. Choosing AOS counts as a negative factor, even for dual intent H-1B holders. H-1B is a temporary work visa for specialty occupations, often used by technology professionals. Dual intent, protected under INA 214 CHUR, allows H-1B holders to pursue a green card without violating their temporary visa status. I-485 is the actual form used to apply for adjustment of status. Indian families are hit especially hard due to PR country caps that create long backlogs in EB1 and EB2 categories. Forcing travel to consulates in India adds unpredictable delays from NVC, National Visa Center, processing and potential 221G administrative reviews, a temporary refusal notice that can add weeks or months. These realities create major family stress, especially for dual professional couples with children who have medical or educational needs. These case studies are illustrative examples based on this brand new policy memorandum. They show how we plan to develop cases moving forward, always making AOS our first and strongest option through comprehensive discretionary packages.
Rome, 20,000 spectators, one epic battle, two warriors, one destiny. But before they can fight for glory, They must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
They should have went to the law offices of Chris M. Ingram. Off to the Lions pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
Case Study 1. Successful adjustment in the United States. Rahul Sharma, 38, has worked on H-1B for 7 years as a senior software engineer at Apple in Cupertino, California. His wife, Neha, is a top data scientist at the same company. They have 2 children, Arav, 6 years old and born in the United States, and Anika, 4 years old and born in India. When Rahul's EB-1 was approved and his priority date became current, we filed I-485 applications for the entire family as our primary strategy. We submitted a detailed 8-page discretionary memorandum that included complete H-1B compliance history showing uninterrupted lawful status, strong Apple letters detailing the couple's joint contributions to major AI-driven projects generating millions in revenue, tax records, community involvement evidence, and proof of California property ownership, plus a family impact statement explaining how consular processing would disrupt Arav's schooling and create emotional strain for Anika. We directly countered the negative factor of choosing AOS by citing dual intent rules and emphasizing harm to U.S. tech interests and family unity. All applications were approved within 4 months. Green cards arrived by mail. Rahul and Neha continued working without interruption, and the children maintained their routines. This success demonstrates that strong, well-prepared cases can still secure AOS under the new policy. Case Study 2. Quick consular processing after a OS denial. Vikram Patel, 42, works as a machine learning specialist at a major technology firm in Austin, Texas. His wife, Meena, is a senior cybersecurity engineer at another leading company. They have a 7-year-old daughter, Maya, born in the United States, and a 5-year-old son, Arjun, born in India. We first pursued AOS aggressively. The discretionary memorandum highlighted their combined STEM contributions, Texas home ownership, tax compliance, and specific hardships. Particularly Maya's need for ongoing specialist medical care in Austin for a chronic condition. Despite this strong package, AOS was denied. The family then shifted to consular processing in Chennai. After NVC qualification, they received a 6-week interview notice. They flew to India a few days early. The interview went smoothly thanks to the well-organized evidence prepared for AOS. Approval came the same day, and passports were returned in 7 business days. Total time away was only 12 days. Maya's medical needs were carefully managed with portable records, and both children adjusted well upon return. This case shows that thorough evidence built for AOS can support smoother consular outcomes when needed. Case Study 3. Extended 221G after AOS denial. Suresh Reddy, 35, serves as a hardware engineer at a major technology company in Seattle, Washington. His wife Lakshmi is a talented AI researcher at another firm. They have 8-year-old Rohan, born in the United States, and 5-year-old twins, Karan and Priyanka, born in India. We first filed for AOS with a comprehensive discretionary package, including detailed H-1B records, strong employer letters on their contributions to sensitive projects, and medical documentation showing one twin needs regular specialist care in Seattle. AOS was denied under the new discretionary standards. During consular processing in Mumbai, a 221G was issued due to the couple's work on export-controlled technologies. The planned short trip stretched to 9 weeks. The family faced significant stress managing medical care remotely and Rohan missing school. The 221G was eventually resolved after 55 days with supplemental documents, and they returned as permanent residents. These scenarios demonstrate the range of possible outcomes and how we build strong cases from day one. Top 5 client questions answered by attorney Chris M. Ingram. Does my H-1B status still protect me from having to leave the country? It provides helpful arguments through dual intent, but we must build a strong discretionary package showing compliance, contributions, and family hardships. Many well-documented cases still receive AOS approval. How long could consular processing actually take? Expect 6 to 18+ months overall. Even after an interview, 221G can add weeks or months. We advise planning conservatively for at least 4 to 8 weeks of disruption. What changes should we make to our I-485 filing now? Replace simple cover letters with a detailed discretionary memorandum. Include employer support letters, tax records, family evidence, and strong arguments about why consular processing would harm your family. What happens to my spouse and children if I must go for an interview in India? We strongly argue for family unity. Extended trips can seriously disrupt schooling or medical care and create strain for dual professional households. Will this policy be overturned or paused by the courts? Strong litigation is expected on multiple grounds. It could be paused or modified, but we prepare every case assuming the policy currently applies. This USCIS policy shift creates real challenges for Indian professionals and their families. However, with strategic preparation and strong advocacy, positive outcomes remain very achievable. At the law offices of Chris M. Ingram, we have updated our templates and are ready to fight for the best possible result in your case. Recommended next steps: schedule a consultation immediately to review your specific situation. Begin gathering evidence of your contributions and family circumstances. Discuss potential work arrangements with your employer. And subscribe to our YouTube channel, Let's Talk U.S. Immigration, for ongoing updates. The American dream is still within reach. Contact our office today.